So, Chapter 2 Essential Requisites of Contract. So, in Article 1318, there is no contract unless the following requisites concur. So, there are essential elements, or those without which no contract can validly exist, regardless of the intentions of the parties. They are also known as requisites of a contract. So, they may be subdivided into two. So, common of those present in all contracts, namely consent, object, and cost. Second is special, or those not common to all contract, or those which must be present only in or peculiar to certain specified contracts. And such peculiarity may be as regards as to form, as for example, public instrument in donation in of immovable property. So, next, consent of the contracting parties. So, consent must be free and given by someone who is sui juris, or one who has capacity to act. Therefore, it must be freely given by the parties and must be an intelligent consent. The party must know what he is consenting. So, if the consent of one party is not freely given, because such as consent was obtained through fraud, violence, intimidation, undue influence, the contract is voidable. This is when it is said that the consent is vitiated. So, in section 1, is the consent is the conformity or concurrence of wills. And with respect to contracts, it is the agreement of the will of one. So, the will of one is contracting party with that of another or others upon the object, the term of the contract. And offers is included in consent. It is a proposal made by one party to another indicating a willingness to enter into a contract. It is more than an expression of desire or hope. It is really a promise to act or to refrain from acting on condition that the terms thereof are accepted by the person to whom it is made. So, example of consent is John offers to buy Clarence's car. The offer is made over the phone. Unknown to John, it is not Clarence at the other end of the line, but his younger brother, one who can perfectly mimic his elder brother voice. One accepts John's offer, successful at imitating his elder brother voice. There is no contract here because there was no consent on Clarence's part. So that is the first example. Then give consent is giving a consent is giving one's conformity to the terms of the contract freely, and voluntarily it is the concurrence of the minds of the parties on the cause and subject matter which will constitute the contract, as well as on the other condition and term thereof to which they voluntarily binds themselves to comply. Consent may be expressly or implied. And forms of acceptance of offer. First is express acceptance. Maybe oral or written. Next is implied acceptance. One that is inferred from the act or conduct. So, meaning of acceptance is the manifestation by the offeree of his assent to all the terms of the offer. Without acceptance, there can be no meeting of the minds between the parties. So, example. A asked to me this question. Will you buy my car for 100,000? If me answered, yes, I accept your offer. Or yes, I agree. Or just yes. The acceptance of me is absolutely or unconditional. But if me proposed to pay only 180,000 for the car, or to buy instead other or another car, or a land of A for 50,000, his acceptance is qualified and becomes a counter offer in this case. Me is now the new offer, and A who was the original offerer, the new offeree. So we have an communication of acceptance. So first is to offerer. The acceptance of the offerer or the acceptance of the offer must be absolute. The other requisite is that the acceptance must be communicated to the offerer. The acceptance may be either expressly or implied. Next is to agent. By legal fiction, an agent is considered an extension of the personality of his principal. So, when offer become ineffective, an offer may be revoked or withdrawn at any time before it is accepted merely by communicating such as intention to the other party. After acceptance, the contract is already perfect. So, however, other grounds which render offer ineffective. So, the above grounds are not exclusive. Thus, failure to comply with the condition of the offer as to the time, place, and the manner of payment. The expiration of the period in the offer of acceptance. The destruction of the thing due before acceptance. So, example of implied acceptance. We have acceptance by promise. Where a person delivered to another certain thing if the latter will pay a certain amount and the other accept by promising to so pay according to the condition of the offer. And acceptance by act. Example, where an offer is made that the offerer will do something else. If the offeree shall do a particular thing and about or either perform his respective act. So, in Section 2, Object of Contracts, in Article 1347, all things which are not outside the commerce of men, including future things, may be the object of a contract. All rights which are not intransmissible may also be the object of contracts. So, no contracts may be entered into upon future inheritance except in cases expressly authorized by law. All service which are not contrary to law, moral, goods, custom, public order, or public policy may likewise by the object of a contract. So, based on Section 2, lahat ng bagay na wala sa labas ng komersyo ng tao, kasama ang bagay sa hinaharap o maaaring maging bagay ng kontrata, lahat na karapatan na hindi maaaring ilipat ay maaari maging bagay ng kontrata. Walang kontrata na maaaring pasukin sa mga mamanahin pa sa hinaharap, maliban sa mga pagkakataon na pinapahintulutan ng batas. So, the object of a contract, it is subject matter. It can be thing, right, or service arising from a contract. If the object of the contract is a thing, it should be within the commerce of man that it alienation it is restricted by law. Accordingly, property of public domination, such as roads, plazas, foreshore lands, are outside the commerce of man, as the law restrict their alienation. A future thing may be by the object of contract. Thus, a composer or other can sell an intellectual which he intends to compose or write even before the work is actually composed or written. Not all right may be the object of contracts, but only transmissible rights. The right the both which is political in nature, marital rights, which are personal right to receive future support and similar other cannot be the subject of contract being transmissible. While future inheritance is a future thing, it cannot be subject of a contract. The reason is that future inheritance is just an inchoate right which comes into realization only after the death of the predecessor. Its amount cannot be exactly determined until the final settlement of the state. So, any partition agreement of the state of the living person by the supposed heirs are void. But partition partition may be the descendant himself of him estate during his lifetime is valid. In case of marriage settlement, future inheritance may be the object of donation. So, in requisite of things as object of contracts, in order that things may be by the object of contract, the following requisite. The thing must be within the commerce of men, that this is legally be the subject of commercial transactions. And it must be impossible legally or physical. And it is must be an existence of capable of coming into existence. And it is must be determinate or determinable without the need of a new contract between the parties. So, in the right as object of contract, so in Article 1348, impossible things or service cannot be the object of contracts. So, impossibility may be because of the nature of the transaction or because of the law, or absolutely and relative. Take note. Generally, the impossibility referred to by the law is absolutely impossibility. So, impossible things. Before I can give you ₱1,000,000, you must fly above like an eagle without any device. Or, the carpenter was obliged to stop the construction of road near the mountain because of the presence of landslide and heavy storm. So that is impossible things. So determination of quantity. So once the object is determinate or a specific thing, no need for a new further agreement between the parties. But when the obligation consists in the delivery of a generic or indeterminate thing, whose quality and circumstance have not stated, there is a need of a new or further agreement between the parties. So, determinate or specific thing of quantity. So, example is the t-shirt Levi's I am wearing, like the previous lessons. So, generic or indeterminate thing is a brand new t-shirt. So, definition of future inheritance is an property or right, not its existence of capable determination at the time of the contract that person inherit in the future. So, we have validity of contracts upon future inheritance. So, general rule. So, except it is case expressly authorized by law, a contract concerning future inheritance is void. So, exceptions. The law permits contract on future inheritance. In the case of donation by reason of marriage between future spouse with respect to the future property, to take effect only in the event or death, to the extent laid down by law in testamentary succession. So another kinds of impossibility, like what I said. So, physical. In physical, when the thing or service in the very nature of things cannot exist, or before, with particularly reference. And legal, when the thing or service is contrary to law, moral, goods, custom, public order, or public policy. So, In Section 3, Cause of Contracts. In Section 3, Article 1350, in one-ruse contract, the cause is understood to be, for each contracting party, the presentation of promise of a thing or service by the other in remuneratory once the service or benefits which is remunerated and it contract of pure beneficence. The merely liberality of the benefactor. So, here in Section 3, in Tagalog, on my understanding, ang pagkakautang na kailangan bigyan ng pangunahing pansin ay dapat nauunawaan ng bawat partido kagaya ng mga bagay ng mga pangako ng bawat isa sa mga bagay na bayaran at serbisyo at benepisyong gawain at ang mga kagalingan at kabutihan na magagawa nito. So, in the kinds of contract with regard to cost, one is onerous. The cost is the mutual understanding or the promise each contracting party makes. So, second is remuneratory. The cost is the service or benefits for which the remuneration is given. Gratitude. Cost is the pure liberality of the benefactor. So, cost is the essential or more proximate purpose which the contract parties have in view at the time of entering into contract. So, example, Casio sold a watch to Timex for 5,000. So, the cost for Timex is the delivery of the watch. For Casio, it is the delivery of the 5,000. And the subject matter is the watch. So, cost distinguished from motive. So, motive, the purely personal private reason which a party has in entering into a contract. So, the condition of the mind which incites to action. The remote, indirect reasons. And the particular reason of a contracting party which does not affect the other party and may be unknown. So, not an essential element of a contract and the illegality of which does not render the contract void. So, cost. So, cost is the immediate direct reason which moves the contracting parties to enter into the contract and justify the creation of a obligation through their will. So, always known to the other contracting party. So, an essential element of a contract. So, the illegality of which affect the validity of a contract. So example is PB sells her house and lot to Edsel for 1 million. So, for PB, the cost or consideration is the 1 million. And her motive or private reason may be to use the money in business or to buy another house. In case PB's motive in selling her property is to defraud Charlie, a creditor, Charlie may be asked for the rescission of the sales. So, requisites of cost. So, requisites, it must exist at the time the contract is entered into. And it must be lawful. and it must be true or real. So, effect of absence of cost. Absence or what of cost means that there is a total lack of any valid consideration for the contract. So, effect of illegality of cost. Illegality of cost implies that there is cost but the same unlawful or illegal. The cost is unlawful if it is contrary to law, moral, goods, custom, public order, or public policy, according to Article 1306. So, for the illustrations, the administrator of the state of Leila de Cinco brought an action against the heirs of Jonel Mapagmahal to declare null and void a deed of sales purportedly executed by Leila de Cinco in favor of Jonel Mapagmahal for 10 million. When the deed of sale was executed, Leila de Cinco was almost 100-year-old and was in weak condition. Jonel was only the driver of Leila with a monthly salary of 15,000. In this case, at the time of the sale, Jonel could not have raised the amount of 10 million as a consideration of the land supposedly sold to him by Leila de Cinco. Therefore, the sale is null and void. So, effect of falsity of cost. By falsity of cost is mean that the contract states a valid consideration but statement is not true. The first always produce the existence of contract if the contract is false. The contract is rendered void because the same actually does not exist. The second does not always produce this effect because it may happen that the hidden but true cost is sufficient to support the contract. If the parties can show that there is another cause and that said cause is true and lawful, then the party shall be bound by the true agreement. For the example, Sandra sells to PB's parcel of land in the deed of sale. 100,000 is stated as the price of the land. If this statement is false, then there is no contract of sale. However, if PB can prove that the contract is founded upon another consideration as when PB was exchanged his car for the land, then the contract of the barter or exchange shall be valid. In this case, the statement of the price is stimulated because it is willfully made. Otherwise stated, there is in fact a real consideration, but that same is not the one stated in the contract. So, for the convenience of the parties and of the courts, it is better that the cost or consideration be stated in the contract. However, in the event that the contract does not state it cost, the presumption of the law operates that the cost exists and it's lawful unless the debtor proves the contrary. So, for the examples, Jeyo issued in favor of JR a promissory note which receipt. 30 days after date, I promised to pay JR or ordered the amount of 1,000 pesos. Although the promissory note does not mention the consideration, the law presume that Jeyo must be receive a consideration for the debt and the same is lawful. So lesion, it is inadequacy of cost, like insufficient price for a thing sold. Exception, together with lesion, there was been fraud, mistake, or undue influence. In case expressly provided by law, following the contract may be rescinded. So that's all. My name is Raylene Matterdan from BSBA 2A.